afternoon to all of you who have taken their time to attend today's event. We are going to talk about navigating high stakes business disputes in a regulation heavy 2026 economy. Well, the very topic when we talk about the regulation heavy 2026, so I think last 5 years have been quite regulation heavy. Am I right? So it is all going to be regulation heavy in the coming another 10 years maybe till the time the dust settles, because we are maneuvering in a new dimension. And we all know when I talk about the new dimension, it's the AI which has taken place in the seats of all the corporations, systems, which is unregulated till now. And more so in relation to the domain of legal sciences, it is totally unregulated. We have DPDP Act now in place. We have DPDP rules which are going to be implemented in some time. But at the same time, those would not be good enough to really regulate the field of law. Like in different domains of industries, we see that there are regulations with regard to the security concerns, the applications, the compliances in relation to the information technology. But that is not there. If suppose tomorrow an evidence has been extracted, taken on record, and somebody manipulated, there's no safeguard. So you may not be a convict, but you can be declared as a convict. You may be a convict, you may be declared as a non-convict, because somebody has changed the evidence itself. There is no regulation to that effect. So while we are talking about there are regulations, last year Government of India had taken a policy decision with regard to in all the matter which are more than 10 crores of worth of contractual value. Arbitration clause will not be there. They went dimensions to mediations. But at the same time, Indian robust system is not robust with regard to mediation as on today. So while we have omitted the arbitration clause, though in the past contracts it is still continuing, but at the same time, CPWD, PWD have removed the arbitration clause per se now, even below 10 crore of contracts. So we would be talking, maneuvering in this background, and there would be other, ideologies, other thinking processes which my panelists, my learned panelists would have. So my first question would be to all of you, one by one. We may start. So I would start with Shweta, my dear friend. So, as a stakeholder, what challenges you may face in 2026 while operating in such a regulation-heavy economy? Your perspective as a lawyer, as a owner of a law firm. So it would be great enlightening your view for entire audience.
Sure. Thank you so much, Vivek, for the question. Good afternoon, everyone. I think, and because the batting starts from me, so I get the field to play properly and completely and thoroughly as much as possible. When we say regulation heavy, look at the kind of regulations that we have at the moment for initiating a business, running a business, and even to close a business. There's just way too many regulations, and what is happening in the process is that there are regulations with respect to your local laws, with respect to your state laws, with respect to your central laws, and if you are also having your business cross border, then international laws. So to have a proper harmony in this kind of an environment where you have multiple challenges with respect to your regulators, it is very difficult to find harmony around it. The second key challenge that I see with respect to being so regulation heavy is the lack of consistency. Because we are talking about the local laws having a central understanding, the central laws having a certain understanding, and your state laws having a certain understanding. So I think there is a lack of harmony. So when we are running the business, if with this kind of regulation heavy environment, it becomes very difficult at that point of time to be able to harmonize all of these laws. And then third, which is the bigger challenge, is unpredictability. I think, yes, last week, in fact, early this week, on Monday and Tuesday, I was in a conference which was on gaming laws. Now there is a certain sense of despondency because of the manner in which, the whole real money game has been stopped. Whether it is right or wrong, I'm not getting into the moral debate. But the fact of the matter is that through a certain law, you are able to stall the entire business. So I see there to be a lack of predictability when it comes to the kind of regulations that we have. So some of these challenges we really need to work around to be able to make the business more, more easier, as we say, that ease of doing business. I think unless and until we are able to provide a certain predictability, certain harmony, and certain reduction in terms of the kind of, compliance challenges that we have, it will be difficult for the organizations and businesses to be able to manage in this kind of a regulatory framework.
Well, wonderfully explained. Predictability is the key. If the system is predictable, you know what has to be done and what is the outcome when you do or take a step in a particular direction. And in particular, I would talk about the litigation. We don't know the predictability. Means matters are listed, they don't reach in the court. The dates are given for another 4 months, 6 months, 8 months, and then again the same thing happen over and again. So this is quietly unpredictable. So we have got the key stakeholders here: the law firms, two owners of the law firms, and two general counsels. So my next means the same question I would see from the perspective at the receiving end, because the general counsel for DLF, Mr. Manish Lamba, is here. So how do you think, Manish, that the regulation heavy system is affecting your company and your lobby as a whole?
So whatever I speak has got nothing to do with my past, present, or future employers. So this is one caveat which I would like to put, and I would take the cue from what Shweta very rightly said. See, what has happened in the last 5 years has not happened in the last 50 years. So therefore, if you are expecting that everybody will have a free field day, that is not to happen. That is not to happen for a simple reason that we are hearing a new world order which is taking place. While we are sitting over here, at least 3 wars are going on. So one is for 4 years, and the other we don't know whether there is a ceasefire or not. And the third big war which is going on is that trade war which is going on in the world. So while the world technologically is getting completely integrated, and there is free flow of men and capital and material, but at the same time new barriers have come up, whether it is US, and if you look at it, we have new barriers with respect to the movement of men, material, and even software and everything which you can think of. So we are living in a new world order. 4 years ago nobody had heard about AI, the manner in which we hear it now, although AI is, as the expression was actually used in 1960. But in the last 4 years, what has happened is with the generative AI, the amount of interest in the application and the manner in which it has done, you cannot leave the world unregulated. So we will have to learn. Regulations are like sometimes like your traffic lights. Now, traffic lights stop you, slow you. But if they are not there, there'll be a chaos outside this hotel, which I face every day while going to Gurgaon. And those who go would realize that what kind of a chaos which is there. So we need some kind of a regulations which are there. And when you will see a company like today, the Magnificent Seven, the large seven companies, out of which two of them have their market capitalization which is more than half the world's GDP. Or maybe we were thinking that which company will, whether Google will reach $4 trillion first, or the Indian economy, whereas Google and the other companies have reached first. So therefore, these regulations and the manner in which AI is going to be there, the kind of information, data which is going to be transferred, the manner in which today crime is happening, the manner in which commerce is happening, we are going to live in a world where regulations are going to be there. The only difficulty is generally people think that everybody is supposed to know the law. That is not possible anymore. Whereas the other maximum which remains the true is that ignorance of law is not an excuse. And therefore, by the time you realize something and you try to settle, you have a new regulation. And this regulation has a problem worldwide. In US also, the number of regulations which have been amended or deleted are not even 5% of the new regulations which have come in the last 5 years. So it is a lawyer's paradise. I can't be complaining much on both sides. We have to live with them, we have to improve them, and that's sadly or truly what it is. Life is going to become more complex, and in this complex world, instead of laws, because laws can't change every day, regulations can change more frequently than the laws, and they are the part of that administrative law. And that book by Wade, which was finding dust, today the entire administrative law is going to be something which the young lawyers must look up to. That's what I feel. It's a free day for lawyers.
Well, very nicely explained, Manish. It's wonderful to hear you on the count of how you have presented your view. You are absolutely correct when you said that regulations are going to be, helpful in the coming scenario. But at the same time, there are so many regulations in all the fields. Definitely, they would be there. But then the burdening with regard to the processes in concerning those regulations. So one regulation is there, but at the same time, it contains several processes. So we can always reduce the processes involved in the regulation. So, taking the cue from you, I move to Mr. Sumesh Dewan on the same question as a stakeholder, what challenges you may face.
Yeah, hi everyone. As a stakeholder, we typically see, the biggest challenge is we as a nation are heavily regulated. And there have been numerous surveys when you do a comparison with Singapore or a lot of countries. So we have MCA, ROC, SEBI, labor laws, so the compliances, and then obviously, listed companies have many more regulations to follow. So typically, as a stakeholder, what we see is, there is no sense of demarcation between a mixed size or a large company, unless, of course, you are not listed. So the number of and quantum of regulations, and now, of course, we have a data protection regulation which has just come in. So the quantum of compliances and overlap of regulations is something that discourages companies to set up businesses. And that's the reason we see a lot of companies will typically still prefer having their operations from Singapore or overseas. Because it may be setting up of a company, the quantum of compliances. And then also as lawyers, we always see, we are always, every week we have to be aware, because every end of every week there are new regulations coming in. And as Manish rightly said, not being aware of a regulation is not an excuse. So the companies, I always say the companies are always on a back foot, because the compliance cost is very, very heavy to comply with every piece of regulation. And I believe every company, we statistically spend 30 to 40% time only in compliances. And probably, I'm sure, as we've heard from a lot of in-house counsels, instead of, growing businesses, majority time is, is in firefighting, is ensuring are we compliant or not compliant with regulations.
Well, we come to the compliance cost, and I suppose more than the compliance means the cost of compliance, it is the cost of non-compliance, which takes us to the new preview of the DPDP rules. So my question to the next panelist, Mr. Amresh, would be, what are the gaps and opportunities you see in current DPDP framework, more so particularly in relation to the compliances and non-compliances? How do you see it?
Sure. So first of all, greetings BW Business World audience and Dr. Bhasin. I have a long association with him. I have not worked in his firm, but I have worked along with him. And as ardent cricket player, where he is the chairman of the Self Cricket Organization, I have often faced his regimented, way of tackling. And, in the inaugural speech, the way he's clarified things, I think whoever missed it, it's a great loss of an opportunity. Now, so far as DPDP is concerned, it was really required because it needed to be aligned with global systems in place. So that came into being in 2023, and with the rules now along with 25, they have created a full spectrum privacy regime. Now, what are the objectives? The objectives are very clear that they must align closely with global regimes such as GDPR and PIPL. Then there is also a 18 months transition period. So within that 18 months transition period, they need to update their IT systems, they need to appoint their DPDOs, and they need to overhaul all their internal policies so as to help build consumer trust and enable cross-border transfer of data and all of that. So we need to look at the essence. The need of the essence of this is that there is no bar of sharing of data, but it's how you take it, how you process it, and what are the checks and balances which come into place, just to make sure that this act being citizen centric has completely lives up to its legislative intent. So therefore it is very, very important that consents are taken, then the withdrawals are taken, then cancellations are taken. It's a tough call. It is evolving. It has to evolve a lot. It has to be seen that at what plane and level this is being construed at. It will, at the lower level, you'll have these individual customers, and at the higher level, you have these global companies from abroad taking data, processing, and so on and so forth. So all of these are going to be very, very well regimented. Now, what are the basic, some of the gaps, that we see currently is that, there are unclear timelines. So, nothing to really panic about, because as this is in an evolution stage, all these things will be sorted out. Then, of course, there are certain exempted limits. So that also needs to get clarified. Then, then you have certain consent-related uncertainties, with regard to children and disabled and so on. Then, breach notification confusion, so that also needs to be sorted out. And, there are security safeguards without standards. So whilst it says that there has to be reasonable security safeguards, it does not detail what those entails. So sectors like banking and telecom, they need, which are quite closely intertwined with cyber city laws and so on, they need to get streamlined. And, then there are regulatory constraints and overriding clauses, that this act has been made to be a predominant act. So how it configures with the other legislations will also be very, very important. So that's what it is.
So thank you, Amrish, for pointing out certain deficiencies and anomalies, and at the same time also pointing out certain very important features of the DPDP rules and act. And I think this is at a very nascent stage, and as the technology will keep on changing, we will be in constant need to change the DPDP rules or act, and maybe some new rules and act with pertaining to the AI. And I envision a scenario, maybe after 5 years or 10 years. Today we use binary computers. Consider a scenario when you have the quantum computers. That would be a great leap towards development of humanities in sciences. But at the same time, the kind of problems it may pose. Today, AI is doing so many things. AI can create the same scenario as we are in without we being there, and AI can talk just like me. So we don't have regular means any particular rules. Well, I am sure AI can. Well, we leave that to the AI's discretion right now. So there are many things which would be changing. Quantum leap would be posing another great, environmental, the tech environmental scenario, which would be difficult to assess, and don't know how the rules would come on that platform. But we come to Mr. Sachin Mishra, who is GC for the Tata Consulting Engineers. Sachin, you must be using the AI, I suppose, in several platforms within the company. In that presupposition, may I ask you the question?
Yeah, I mean, just to tell you, Vivek, AI means, I mean, in engineering firm, the drone has been used for a long, and drone surveys has been used for geological surveys and those things. But that was more to do with, machine kind
Manual.
of manualing.
Okay.
But AI is as such, as Manish has said, and I tell you, somewhere we use AI for investigation purposes, internal investigation purposes. Being in compliance officer of AML and bribery corruption policy, earlier we used to go through the email chain and those things, but now you put maybe lakhs of email of accused in that particular system, and it gives you exact trail what to go, and it reduces your time by 70 to 80%. That's the biggest benefit we have seen in coming days. But that's a negative part of it. Come to the positive part of the AI. See, contract management, we execute roughly around 1700 to 1800 contracts a year, which means we review more than 6000 contracts a year, 5000, 6000 contract a year. And with a team of 11 people, it would be very difficult if you don't have a proper system in place which can give you or which can highlight the risk of each and every contract. See, each contract had some boilerplate clauses and some identifiable clauses which you can just review, take your company's protection in mind, and you can give your views. So there I see it's a really revolutionary and we are getting benefit of it. Not reducing the headcount, but headcount is being used for more productive use of the wordings, more productive use of the how we can negotiate that clause. Earlier, when you used to review the, if you have so much quantum of the contracts, you cannot review all the contracts and then give your intellectual power to that. But when you know that this is the focus area and where I have to give my views, I can take some best examples of the same clauses across the globe, not necessarily in India. I can take the same clause, engineering clause being used in France or somewhere, and it's a educative things to the counterparty also. Many time, government contracts are written on a basis of CVC guideline or maybe OM guideline of the Ministry of Finance. To tell them something that this is being used other part of the world is something which is more, I think today it's more openly welcomed by them. So that's a more positive side of the AI, and we are using it very frequently, those things. So contract management, investigation, and then something called as, earlier we used to say the risk management committee. Today it's not risk management, it's called modern compliance and risk management. You need to understand that what are the modern risk of the corporates, which is very important to understand. 5 years back, none of the audit committee may have the terms of reference called cyber risk or digital risk. Today, almost all the audit committees have that particular agenda. And to educate the audit committee, earlier the audit committee was more financially acumen, you can able to read the balance sheet and all. No, that's the era now, and that's the era for very long, 60, 70 years. I'm not saying that era is gone, but at the same time, you need a person who is equipped to understand how the AI can affect the company in the kind of cyber risk and those things. So that's the third area which is we have seen as a corporate, which is coming in the boardroom discussion, in the corporate discussion, and that's more positive side of it. We don't see that AI is going to replace those things, but yeah, it's going to hand in a more positive way to the corporate function. That's for something I would say.
Just to add to that, I mean, whilst AI is going to be very beneficial in many, many respects, but we have to also bear in mind that there's a recent judgment of the Delhi High Court where Cristiano Lobton, where it says that AI chat GPT cannot be the platform to ascertain facts and legal. And I quite agree with it because, if you look at law, the way it progresses and the way it transpires, there's something called the Euclid's principle, where every judgment is distinguishable and it is in relation to a context. The question is whether the AI is adept enough to kind of perceive that and, make it applicable. So the creativity of the human mind cannot be replaced. Yes, AI will be there to facilitate things, but in my view, the way the education system of the legal arena is improved, lawyers can also research in a very, very competent manner and more focused. So sometimes, this, and we have experienced it. Sometimes you want a particular contract to be drifted in a particular way, and it throws up a very, very weird, kind of a contract. So, it has to be treated with caution. It needs to evolve quite a bit and reach that standard. But my final conclusion states that it cannot replace the creativity and the creative mind of a human.
Yeah.
I'll just add on to what Amaresh has said. And I think while I agree with all that he has mentioned, I feel that to only use AI for the purposes of research is undermining the ability of AI. It has immense potential, immense, usage. As Sachin also mentioned, I think so far as contract management is concerned, it definitely is going to be of huge relevance. And not just that, I feel that it is also likely to reduce the disputes, because if you are able to ensure that all your clauses are mapped and you are able to then thereafter also act upon those clauses, I think most of the disputes that we see are around non-compliance of certain clauses. And if we are able to map those clauses, I think it is definitely going to also help us reduce disputes. The second, I think that where we also, and I think the government has started working on it, some courts have also started to working on it, is to use the AI tool also for dispute management and dispute predictability. I think it is also becoming more and more relevant to understand if there is a dispute of a certain kind, and if it is actually run through the case history and the data which is available before the court's records, we will be able to also understand what is the kind of likely outcome. It may not be accurate because, of course, human intervention will still be required, but it is at least giving you a certain likely outcome which can be used for that purpose. And the third, which is very important, is also in cases of mediation, because if you are trying to settle a dispute and if you have an understanding of what is the kind of dispute that it is and what is the kind of outcome that is likely to happen, I think it will also help or enable the organizations try and settle the dispute. So I think there is a lot more that can be done with the
I
AI than
totally
to
agree.
just talk about.
Manish, you want to say
Just
something?
to add to what Shweta has said, see, ultimately we will have to realize that a company, NVIDIA, today, which is the backbone for AI, its market cap is more than the GDP of India.
Yeah.
In last 1 year, the kind of it has added $1 trillion to its balance to its market cap. Now, the only difficulty with the legal fraternity is that the last big change which came in the legal system was a Microsoft Word.
20.
So it's been almost more than almost 2 decades,
More than 2 decades.
and most of the lawyers have not been able to rise or think beyond it. While intelligence has become artificial, stupidity still remains human and natural.
No, I don't agree. Even AI is quite stupid on certain counts.
It is, but it is not. It is not as natural and as human, which it is. So it makes errors, but it makes an error. I'll just give you one example. When the car was being made, Tesla. So this same question was being asked and debated upon. What will happen if there is an accident? So what happens? How many of you know how to drive a car? Raise your hand. Almost everybody knows. See, what happens, we all have learned how to drive a car, but we have made the same mistake. गाड़ी चलाते हैं बंद हो जाती है. We same the same mistake of taking a right turn or a left turn or giving an indicator or not giving an indicator. But when an AI-driven car makes a mistake once and there is an accident, all the cars in United States of America learn that. So therefore, they don't make the same mistake again. Me, my wife, my daughter, my son, my father have made almost the same mistakes, if not all, most of them, while we were driving. We learned how to drive a car. The same mistakes are not made by, insofar as AI is concerned. AI, if it is used for if blockchain, AI, and your quantum computing is used for the purposes of land records, 50% of the land disputes will not be there. Yesterday, I was at a conference, and Justice Mohan said that 60% of the cases will have no right to exist insofar as the check bouncing and things of that nature is concerned. 40% of that 40%, 60% time will be free for the judiciary, and then there will be no excuses for us to say that we don't have the time to hear all the cases. And most of the time of the judiciary, if you look at somebody was to do an analysis, they will come to a conclusion that the administrative matters take most of the time of the court. That is the area that we need easiest and we need to strike, and we will be able to use them. I'm not saying use it for the purposes of replacement, use it wherever it is possible. And once that is done, a lot of humans' dignity will be preserved. And what I say is that knowledge is free. Today, anything in my era, anybody who knew the 180 country capitals was considered to be an intelligent person. But today, at a click of a button on your mobile phone, that is available.
Let me go.
So that level, at when Mr. Bhasin's era was there, anybody who know do ka, dhai ka, teen ka, sawa ka, pahada jise aata tha, he was considered as a very intelligent person. Today, I don't need to know 2.5, 3.5 pahada. So what we respect Bhasin Saab sitting over here is for his wisdom. Knowledge and intelligence will come in the lower of the hierarchy. So I understand we're not talking about artificial wisdom. Artificial wisdom will there, and that is why people will pay you for your expertise and wise advice. They will stop paying you for information, knowledge, and content. So
We have among us Dr. Lalit Bhasin. I invite some comment from him. We would be, benefited with his wisdom on the topic.
Thank you. What was the theme of this session? It has disappeared from there.
Okay, navigating high-stake business disputes.
Yeah, navigating.
High-stakes business disputes.
Firstly, high stakes disputes, they get automatically resolved because the parties which are involved in high stakes disputes, they can afford, you see, to go for arbitration in US, in India, whether it is Vedanta, whether it is Adani, Ambani and all that, they take care of themselves. This session ought to have been on dispute resolution, business dispute resolution, not high stakes. High stake is an academic thing, you see. It is superficial. They get resolved. They can wait for years also. Second is, yes, observations have been made about regulations. I can understand if you say that we have too many laws, we have overlapping laws, we have ill-drafted laws, we have outdated laws. That I can understand. But so long as laws are there, there are bound to be regulations. How to implement and enforce those laws. Therefore, first requirement is rationalization of laws. There should be a rationalization. We have brought in the labor codes, old wine in new bottle. Most of the provisions are the same. Something has been added. But when we say that we are over-regulated, is it not a bogey that we are raising? Everything, you see, has increased in volumes. The business, the profits, the shareholding of the companies. Earlier it used to be in some thousands. Then it became into lakhs. Now it is in crores and people are talking of 1 billion, trillion, you see, economies.
Correct.
So the cost of compliances also has to go up. So that is no excuse to say, oh, we have so many compliances to do. Increase your manpower, increase your compliances, and as Shweta said, wherever possible, use AI, use technology to reduce the cost. So in my view, this is like an escapist point of view that we are over-regulated. That is my submission.
Thank you so much, sir. I said in in between the discussion that regulations are bound to be there. We only can say that the processes pertaining to the regulations can be reduced. So that's the statement I made. Means that's confirmation.
I think the
you said, sir.
government of India has that agenda that insofar as the process reforms is going to be the second generation of reforms.
Yes, yes.
The exact expression which Sanjeev Sanyal used was that they are now going to look at that the process reforms is going to take. Substantive reforms
Yes.
have already taken. They are identifying those processes where first you have to go and upload your document, and then you have to sign and give a physical document itself, and then you have to go and make 2 copies and things of that nature. So the government is, it looks like, is conscious of the fact that the process reform, it is not only the substantive law reforms which are important, but the with digitalization, automation, and now AI, we will be taking care of a lot of process reforms. So that is something which we,
Your comments are very much welcome, sir, because you pointed out in a much better way that you all could have done.
Vivek sir, I said that intelligence is replaceable, wisdom is not.
Yeah, means that comes to a point. Means ChatGPT has the transientness of say around 55%, and Gemini has a transientness of around 88%. So that is almost near the human wisdom. So when we talk about the transientness of the AI, that is the human wisdom. So if suppose it crosses 100%, so that is almost identically behaving in the same manner as the Vivek in wisdom says. So
I still disagree with you.
nonetheless,
Spanner in the wheel has already been introduced, by the courts when they say that AI has to be treated with a lot of caution. They
That's-
don't have an evidentiary value, and lot needs to be done, lot needs to be harmonized.
see, we are all concentrating on AI. We are forgetting one fact, one very, very relevant fact. Generative AI. Generative AI is altogether means it's not identical to AI. For the textual purpose, generative AI can be used by large language modules, LLMs, which we say conventionally. And that way, today we have the keyword search while doing the research with regard to the judgments and other things. We could have contextual search like we do in the chat GPT. Similarly, means it would bring the same results. Okay, these particular paragraphs of these judgments, several judgments, it will bring out. And then today we have crores of papers which have already been digitized by the Supreme Court, High Court, trial courts. So this is that time where we need to use these LLMs to develop that generative AI so that 3 benefits can come immediately within say a span of 3 to 5 years, which I had suggested 2 years back to the Honorable Chief Justice also in a written note. 50% of the disputes pending in the court, which is almost around 5 to 6 crore courts and tribunals, would reduce within 3 to 5 years. That could have the capacity. But at the same time, we do not, till now we have not been able to do this. There are other benefits which can occur. Well, coming back to our, principal questions here now. Last year, as I talked about, that there had been arbitration clause removal pertaining to the contracts. How do you see, means I have this question from all the panelists, means what is the impact that is going to happen with regard to the government contracts in the coming time, as you see, and whether it would be beneficial for the litigant and India's image in the international world.
Yes, so once that Mediation Act has come into force, there has been a paradigm shift in how people are looking at it. In fact, the Ministry of Finance has already indicated it to the public sectors and the instrumentalities of the state to adopt the mediation route. So, that's what it is. The mediation route has a lot of benefits, and the disadvantages of arbitration is something that doesn't need to be discussed here. It's all well known that how time consuming it is, how heavy litigation costs and so on and so forth. Mediation, rightly pointed out by Sir, that you don't need the law.
Shweta is nodding in negative, so I want to take the Shweta's view immediately because I have to wrap up in 5 minutes.
Yeah, so I'm just taking it from Mr. Bhasin's cue.
So after we finish this round, I will take one suggestion, as you may want to give to the government, in relation to either the dispute resolution or the regulatory framework. But Shweta, yeah, you want to say something? Sorry, I'm cutting you in there.
I just want to add to say that arbitration has not failed. I'm sorry, but that is not the correct interpretation. Arbitration has not failed. The lawyers have failed. It is the creativity of the lawyers where we find the scope for intervention at every stage to the court. And the courts have failed because the courts are intervening at different stages. So I would not agree to say that arbitration has failed. The purpose for arbitration was different. It was to take the disputes out of the court's regime, and it was only the court's role was only supervisory to understand if there is any problem, to intervene at the stage of Section 34. The courts have, the arbitration has become a very favorite baby to talk about while it comes to conferences, while it goes to courts in Section 34. But it is not required to be, intervene at this stage, the manner in which it is being done.
All
It
right,
is
we
not
have-
an appeal.
Before I miss the point, is that if one has looked at the DMRC judgment, where the courts have used the extraordinary powers
Yes.
to kind of set aside the judicial restraint and have actively intervened to sort many issues out, is vindicative of two things. One, that how the arbitration is failing, and secondly, it is setting an example as how things need to be streamlined.
Yeah, Mr. Dewan, you want to say something?
Hi. So, I have a little different take. I think the the biggest challenge we face is we don't have any institutional arbitration. Unlike, typically we as a law firm would see every contract, any foreign company would insist on a SIAC or ICC. We unfortunately, even after 60 or 70 years, are unable to create. We have so many arbitration institutions, but a formidable institution like SIAC
They're mostly working at ad hoc.
working ad hoc. We don't have institutionalized
Court appointed
arbitration.
and
The
all.
timelines are always, of course, as Shweta rightly said, there's always a judicial intervention, and we are over reliant on retired judges for arbitration, who are more
Yes.
than I work without being prejudiced. I'm happy to say, there is always a welcome thing. Okay, fine. There's always extensions being given, so there is no time bound process. In fact, on the contrary, a lot of our clients feel, even if, they will go to SIAC, get arbitration in a time-bound manner, but of course, then they face the bigger challenge of, enforcement of the awards. And also, lastly, I will say, the mediation, having issues like, all commercial matters have to be first referred to mediation has been a miserable failure. Because when companies
Because
are
we don't have trained mediators. We do not have.
No,
I mean, just mere training is not good enough. The kind of training, 40 hours, 60 hours,
exactly.
is not good enough.
And
We
forcing
don't make good mediators.
companies to say that, first you go for a commercial mediation and then you file a recovery case. So that means you are eventually waiting for 1 year almost before you can actually go and initiate a proceedings for recovery. So
Yeah, Mr. Mishra wants to say something.
Not on the mediation
Then-
or arbitration front, but on the regulatory front, I must say that compliance is not in just a paperwork; it's an infrastructure now for corporates. It's not just in paperwork.
Thank you.
or this thing.
Manish, the words of wisdom to close the discussion.
No, see, we have to. We can't blame lawyers or the system and things of that nature. The
Thank you for
polity
not
might-
blaming me.
Yeah, yeah, of course. The entire polity has failed, and I have not cross-verified it. But this situation was there and Justice Narayan had said in one of the speeches that for 100 years in U.S. arbitration was banned in some of the states. So therefore, whenever there is rough justice, whenever there is something, I think some introspection is required. We need to understand how to improve the system. We don't need to throw the baby along with the bathwater. And
Sir,
this
I want to
system-
take a comment from you also on this. The last.
So what is required is, as they say, that 3Gs needs to be introduced. A, geography. So therefore, it need not be concentrated in Delhi and the big cities. And second 3 is generation. So I think we must have arbitrators which are less than 40 years of age. So the third is green. We need not appear in person. So these 3Gs is something which we need to introduce, and that will improve the quality of arbitrations that we have.
Quite applaudable. Thank you so much, sir. Your wisdom.
My brief comment is litigation has totally failed with nearly 6 crore cases. And I don't agree with Shweta that arbitration has some roots here. No. Arbitration has totally failed, as I said in my opening inaugural speech today, two reasons. Judges who retire, they have cartelized arbitration here, cartelized it really.
I totally
And
agree with
then, secondly, judges, sitting judges, the intervention by the courts. So arbitration has not taken off.
the environment did not really fructify properly, and
No. Therefore, Indian, you see, parties, they would prefer to go to SEAC than to get, you see, matters arbitrated upon in India. And my last message, you see, to this august panel and the participant is mediation is the only answer. But for that, you don't need a law. You need a change in the mindset of people, the clients, the lawyers, the general counsel, in-house, everyone.
wonderful. With today's wisdom, we move forward to one last comment from
just one
everyone.
second.
One
Yeah.
suggestion. One suggestion each of you, whatever you want to say.
So
in half a minute, 30 seconds.
So I think for me, I still say the most important change is required is regulatory ease of doing business. Government
Thank you.
is taking steps, but a long way to go.
Mr. Mishra,
Interconnections of the regulators is very important.
very well. Shweta,
I think there are two things. One is making the timelines mandatory when it is provided for in the statute. I spoke about it in CII as well, but that's something that is now started to pain. And second is don't make mediation mandatory. Let it be optional for the parties to opt for it, because PIMS otherwise in Commercial Courts Act has also substantially failed.
Manish.
I think we must now focus on the procedural reforms and the judicial system. I'm not saying judiciary.
Okay.
The judicial system requires a shake-up. We have had it, some of us have had it too good for too long, and we must give way to new ideas, and we must do whatever is necessary. If with the present speed we were to go, we will take 300 years for all the cases to resolve, and once the message goes to the masses, they will lose faith in the system. Before they do so, we must do all that what is necessary, including use of AI, if that be so.
Amresh.
Yeah, I mean, pitch for mediation, make it very, very robust. You know, the Commercial Court Act mediation process has largely been very, very successful. Maybe at a lower, at a lower level, but I think that's what is the need of the hour, keeping everything in perspective.
Well, thank you so much. These are wonderful suggestions. My only suggestion is let's have more disputes. Thank you.